we were studying decree. It has been defined in section 2, subsection 2, CPC. So decree means formal expression of an adjudication so far as the court expressing it conclusively determines the rights of the parties. So every decree under section 96 is appealable. Section 96 gives the right of appeal. When the statute gives that a person may file an appeal, it is a right of appeal. So when appeal is a right, wherever there is a decree, that is appealable, but it is subject to law. What does it mean when we say that decree is appealable but subject to law? It means that if there is any other provisions in the law which prohibits the filing of appeal, that shall prevail upon. So there are two exceptions to this. Whenever we say that decree is appealable, then we will say that every decree is appealable with the exception of two. One is a consent decree. Consent decree is not appealable. And the second is a decree passed under section 9 of Specific Relief Act. When a suit for possession is filed under section 9 and that suit is decreed, it is not appealable. Generally it is understood that it is summary in nature. Because it is summary in nature, hence this decree should not be appealable. So the decree under section 9 is not appealable. There are certain orders which are appealable, but all orders are not appealable. Section 104 of CPC prescribes certain orders to be appealable. Only those orders which have been enumerated under section 104 are appealable. And Order 43 Rule 1 states the orders which are appealable. So meaning thereby that when every decree is appealable, every order is not appealable. Only those orders are appealable which have been enumerated in Order 43 Rule 1 and which have been given under section 104. Those orders are appealable. But when no appeal lies, then what is the remedy available? Then in certain cases revision is competent. But where appeal lies, revision is not competent. So revision is filed under section 115 of Code of Civil Procedure. So it gives three grounds of filing revision. The court had the jurisdiction, but it did not exercise the jurisdiction. The court did not have the jurisdiction, it exercised the jurisdiction. The court committed material irregularity. So these are the grounds for revision. So far as the decree appeal is concerned, it is not a specification of grounds. There may be as many as innumerable grounds of appeal. In every appeal there are different grounds. So the ground means, when we talk of a ground, what does it mean? When we say that there are three grounds for revision and there are innumerable grounds for appeal, then what does the ground mean? So in order to understand the ground, we have to see the definition of judgment. Judgment means statement of a judge of the grounds of decree or order. Now here the word grounds has been used for the purpose of pronouncement of an order or pronouncement of a judgment. So when we talk of a ground, we have certain meaning thereof. ground means finding of a fact and digging out the reality. So these are brought in the mind of a judge with the help of evidence. When there is evidence on the file, from the evidence a judge concludes as to what are the facts and what are the realities. Reality and facts are two different things. Find out the fact and dig out the reality. So these are the grounds for making the judgment. So same is the case with appeal, that there are certain grounds, meaning there are certain facts which are to be found, and there are certain realities which are to be dug. So when we talk of the facts, we mean to say that there is no limit of the facts which can be ascertained. So when the evidence is produced by the parties is on the file, we find the grounds of judgment from that evidence. So when we file an appeal from the decree, we give certain grounds of attack. What are the grounds which you enumerate in your memorandum of appeal for the purpose of attacking the decree? And those grounds are not limited. But so far as the revision is concerned, the grounds are limited. These are only 3 grounds which I have already told you. Under section 115, there are grounds, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in the exercise of a jurisdiction illegally or with material irregularity. So these are the grounds which have been given under section 115 for the purpose of revision. So whenever a revision is filed, we are to confine ourselves on these grounds. Out of these grounds, we cannot file any revision petition. But when a revision is filed, the revision is filed when the case is decided. There is a distinction between the suit decided and a case decided. The suit is decided through judgment or final order, but the case decided is a finding of a particular point. When a court decides a particular point, a particular issue, a particular fact which affects the rights of the parties, or which has effect on the suit, or which can be determined by the court for the proper adjudication. So that is called case decided. So revision is competent only when there is a case decided, and appeal is competent when there is a decree or there is an appealable order. When there is an appealable order, appeal is competent. When there is a decree, appeal is competent. And when there is a case decided, then the revision is competent. Now the question is as to what is the distinction between appeal and revision. There is a fundamental distinction between the two, and that is, I usually say that revision is vertical, while an appeal is horizontal. Appeal is horizontal, revision is vertical. So this is a fundamental distinction between the two. Now in order to understand the horizontality and the verticality, we are to see that in cases there are two parties before the court standing in front of each other. So they are standing horizontally. When the court is deciding the rights, duties and the wrongs, the court is determining them between the parties. So this is called horizontal adjudication. When the court declares rights of a particular person, and when the court decides the extinction of rights, when the court declares the rights, when the court gives adjudication on the execution of certain rights, certain illegalities, certain irregularities, certain causes of actions, and all that which is material for the purpose of adjudication of the suit, then that is called the adjudication by the court between the parties, and that is horizontal. And the rights of the parties are determined between the two persons, two parties, two factors, two ingredients, whatsoever you may say. So this is called horizontal. But when the revision is adjudicated upon, the court is not deciding horizontally, the court is deciding vertically, meaning thereby that there is an adjudication on the judgment of the court. So there is a lower judgment court and there is a revisional court. There is a court which passed the order, which passed the judgment, which passed the case, which passed anything, which decided a case. Then there is a supervisory jurisdiction of the revisional court. So that jurisdiction is exercised in order to see what the lower court did. It touches the jurisdiction of the lower court, whether it was properly exercised or not, whether the court had the jurisdiction to do a particular act, whether the court did not have the jurisdiction to do a particular act, whether the court committed material irregularity, whether the court did not do what it was expected to do in a particular case. So in this situation, it is a vertical determination. So the fundamental distinction between revision and appeal is that revision is vertical, appeal is horizontal. The second distinction is that appeal is a right. When the statute provides that an appeal is competent, it is a right of party, while revision is discretionary with the court. It is not a right of the party. It is not right of the party because it does not determine the rights of the parties. So it is not right of the party. The revision determines the judgment of the lower court. The case decided by the lower court is adjudicated upon. So it is discretionary with the appellate court, with the revisional court, with the court having supervisory jurisdiction to determine whether or not the lower court in a case decided it properly in accordance with the law, exercising its jurisdiction as the law requires. So there is a distinction between the two, that appeal is a right while revision is discretionary. Another distinction is that appeal is continuation of suit. Revision is not continuation of suit because revision has certain limits. So there are certain limitations imposed on the revision, while the appeal is continuation of the suit, meaning thereby that the whole subject matter is transferred from the lower court to the appellate forum, and all the questions are reopened by the appellate court. So when all the questions are reopened by the appellate court, so the appellate court will be exercising the jurisdiction once again in the same suit as the lower court had been doing. While in the revision petition, the whole matter is not opened, but only the odd case decided by the lower court is determined, whether it was decided in accordance with the law or it was not decided according to the law. So the scope of appeal is wider. The scope of appeal is wider, while the scope of is limited. Limited in the sense that only section 115 enumerates only 3 grounds. So these are the limited grounds for the purpose of revision. When we are filing a revision, we cannot go out of these 3 grounds. So the revision is limited to these grounds, while the appeal is not limited. As I have already told you, that appeal has several grounds. You may attack any judgment or order on several grounds. All those grounds which may be enabling you to upset the judgment, to set aside the judgment, to set aside the order, to rescind the order, to alter the order, those all grounds are available. So the scope of appeal is wider than that of the revision. Only 3 ingredients are. The next difference is, where there is an appeal, revision does not lie. If a case is open to appeal, revision is not competent. It means that revision lies only in those cases which have been decided, but wherefrom no appeal lies. If appeal lies, revision is incompetent. If the appeal does not lie and there is a case decided and there are 3 grounds available, then the revision is competent. There are certain factors that appeal is always a right of a party and it determines the rights of the parties. As the lower court determines the rights, in the similar way appellate court determines the rights of the parties. So the appeal is competent from a judgment or from a decree or appealable order, while the revision is competent only when there is a case decided. All questions are opened in appeal but not in revision.